My name is Rob Freedman. I'm a partner with the project finance practice of Shearman Sterling in New York. What you had in California was a number of years of buildup of renewable energy projects and other energy assets which were contracted with PG&E, and the important part about it, the unique aspect of that, was the contracts were really done under a formal process. They were put out to bid, and then in consideration of the bid there was a CPUC, or a utility commission process, to approve the contract. So you had a significant amount of assets that were contracted with PG&E and then ultimately received financing. So you had these individually financed projects with PG&E credit. And because a lot of these deals had long-term contracts, 20 plus years, they really lent themselves to financing in the private placement market. So after the wildfires of 2017, 2018, the pressure on PG&E, even though they were what would be referred to as a solvent debtor, the pressure on them to resolve all the cases and the mechanisms for them to resolve the cases really pushed them into bankruptcy. And at that point, all of the projects that were contracted with PG&E, or many of those projects, then ended up in default because of the off-taker bankruptcy. The private placement workout process is similar to other processes, and in particular looking at the project finance processes. So deals that were financed on the basis of long-term revenue with PG&E as an off-taker. And the unique thing about this situation was that you had sponsors, in many cases the top-tier sponsors in the market, who were still very interested in the projects, and the projects were in most cases performing very well. And even when PG&E filed, the off-taker was still performing under the agreements. So you had a situation with interested sponsors and interested investors coming to the table. So it wasn't necessarily a regular workout scenario where someone may have been the sponsor, for example, or the borrower may have been at fault in this case. Where the private placement market is different from the bank market is you're pulling together a group that's not necessarily represented by one agent or one arranger at that time of the workout. So you're dealing with a lot of different interests. The larger the investor group, the more coordination that has to be done. And some of those deals also not only had private placement pieces, but they have commercial bank, or they have letters of credit involved, other constituencies in there as well. So it's really the main challenges, or one of the main challenges in these deals, is pulling together kind of the different interests and the dynamics between sponsors who are, who, as I said, have not really done anything wrong with the project itself, and the investors, though, who are still really very interested, obviously, in protecting their long-term investments in light of this off-taker bankruptcy. One significant thing to do is get ready to settle in for the long haul. In particular, when you're dealing with a situation of a utility bankruptcy, which doesn't happen very often, but when it happens, it tends to be complicated and it tends to be long. When PG&E first went into bankruptcy, there were predictions that the case could take 4 years. In fact, it looks like, thankfully, maybe they will emerge, hopefully within 18 months or so of filing, so quicker than was originally expected. But it's really waiting it out and being prepared to ride out for the long term, and also be creative and be thoughtful and be ready to work and negotiate with the sponsors. And then, as I said earlier, in particular, in this case, you have interested sponsors and you have projects that are working. So it's about the investors really working to protect their interests, but thinking about the long term and being ready to wait this out for the long term, given that the bankruptcy process itself really could take a significant period of time. Even in this case, which is relatively quick, it would still be at least 18 months or so.